Hello, everybody. I'm looking forward to today's conversation with Tiffany Lesnik. She has been around Call to Peace Ministries, I think, almost since the beginning. And I'm so excited that she's here today. I'm going to go ahead and let her introduce herself and tell who she is before we get started. So, Tiffany, can you tell everybody hello and who you are?
Yes. Hi, Lauren. Thank you so much for having me. I am Tiffany Lesnik. I am a family law attorney in Raleigh, North Carolina, and I practice primarily in the areas of high conflict divorce, high conflict custody, and domestic violence.
That's awesome. And we are so grateful for you. She has been on the board of Call to Peace Ministries for several years. Her husband, Richard, still serves on the board. So they are very active with Call to Peace Ministries and sponsored our vigil and huge supporters of Call to Peace. So we are extremely grateful for them. And I'm excited because I went into several of our private groups and I said, what questions do you have for Tiffany? And I had a lot of responses and a lot of questions. And so today we're going to dive into those questions. Before we do, I thought let's start with some very basics. Just because I like, even I don't understand the definitions of some of these things, but there's three definitions that you need to understand before we start. And that is, I want Tiffany to define, according to the state of North Carolina law, what is domestic violence, what is domestic abuse, and what is coercive control.
So, that's an amazing, excellent question, Lauren. And it's really important to draw the distinction that every state defines domestic violence in a different way. So all laws across the states are going to be completely different. So how North Carolina defines domestic violence will not be the same as how Florida, South Carolina, Minnesota, et cetera, defines it. So it's very important you can just go online and look for the domestic violence definition statutes in your state to see specifically how your state defines it. Most women misinterpret what domestic violence means in their state. They tend to think it's only physical abuse. And in fact, the statutes have a much broader definition of what domestic violence is in North Carolina or in their particular state. For our state in North Carolina, the statute defines it's domestic violence. It's not really called domestic abuse. And in North Carolina, domestic violence is the commission of one or more. So it can be just one. It doesn't have to be continuous acts of certain acts upon a person or a minor child that resides with that person. And those acts include either attempting to cause bodily injury or, in fact, intentionally causing bodily injury. So let's say your spouse goes to strike you or goes to hit you or come after you in any way. That counts as domestic violence, even if they don't actually touch you. Okay. Also placing you, this is the one that I usually go to court over, but placing you in continued fear, continued harassment that rises to the level to inflict substantial emotional distress. So that is a very long kind of definition. What the heck does that mean? Those are all those behaviors, the yelling, the cussing, the calling you names, the following you around, the taking your phone, taking the keys to your car, waking you up in the middle of the night, not letting you leave your house, threatening you, all of those things that have you walking around on pins and needles all of the time, that rise to the level of substantial emotional distress. So you feeling afraid, you feeling nervous, causing you to have stomach aches, not being able to sleep, feeling like you need some support from therapy or going to a doctor. You need to get on medication because this person's behavior is making you physically and psychologically unwell. That meets the statutory requirements for domestic violence. And we also have part of the statute which recognizes rape and sexual assault as a form of domestic violence as well. So it's not just physical abuse. It's a very broad statute. With regard to coercive control, we don't recognize coercive control in the state. It's not defined statutorily in North Carolina. And in fact, there are many attorneys and judges who I don't think would even know what the definition of coercive control is or what that term means. I think that's a term that folks in the industry particularly domestic abuse and domestic violence experts, are going to be a lot more familiar with. So when you are pleading your case or you're talking to a legal expert or a judge about the abuse or violence going on in your home, I would probably encourage you not to use the term coercive control.
Thank you. That is really helpful. I'm learning here too. So thank you for explaining that. So I have my first question, and this is a really good question because this comes up a lot for women. Can a spouse take their children and leave the house, or can they leave the house themselves without facing legal consequences if there's no criminal level of abuse? A friend was advised by an attorney to not leave the house as it might be considered abandonment. I often suggest that a victim take the children and leave, but I'm unsure of the repercussions if they don't qualify for a restraining order. Additionally, is it safe to take the children and live in a different residence once a claim is filed? So it's a couple questions there. So let's kind of pick that apart.
Yes. So the first part of that question, can a spouse take their children and leave the house? I think we could look at that in two ways. One, could the abuser take the children and leave the house? And could the victim or the survivor take the children and leave the house in order to seek safety? If we could break that question down into two parts. The answer to that question is yes and yes, right? So biological parents have inherent constitutional rights to their children, unless there is a court order that's put into place. So either parent could take the children and leave the house. And many times abusers will take children and leave the house and refuse to allow mom to see the children as a form of coercive control, right? As a form of control. So the other part of that question, can she take her children and leave the house in order to flee or seek safety? And the answer to that question is absolutely, she can do that. Could there be legal consequences for her doing that? It really depends. So it's going to depend on your jurisdiction, what county you live in, how far you move. So I would not encourage you to leave the state. I may not encourage you to move hundreds and hundreds of miles away. There could be repercussions for doing that. But if you're moving locally, there should be less legal repercussions. In the state of North Carolina, you must physically separate from your spouse in order to qualify for absolute divorce. So it is a requirement under our law to physically separate. And Lauren, I publish a little primer or a little article that's called "The Top Lies Abusers Tell." And one of the top lies they always tell is that if you leave and you take the children, that I'm going to sue or I'm going to file for abandonment. We hear this all the time, and it's one of the lies that they tell in order to keep women trapped in that oppressive, abusive environment. And it simply isn't true. You can't you can't press charges for abandonment in North Carolina. Now, that may be different in other states, right? But here, that's not the case. It is a factor. Abandonment is a factor in marital misconduct and alimony. But abandonment is something completely different. That would be like if you leave and you go to Hawaii and you're never seen again or something like that. So that's not what we're talking about when you have a justifiable reason for leaving due to abuse.
Wow, that is really helpful. Thank you so much. And then also, I have a question for you. If a woman leaves, kind of another part of this question is, if she leaves and doesn't take her children, can she also be considered abandoning her children? And I've heard women ask about that too. Should I take my children? Should I not? And I know a lot of times as advocates in our area be like, do not leave without your kids. What do you
Yeah.
have to say about that?
That is such a hard question too, because there are times when abusive spouses have already started the alienation process with our kids, and particularly with older children, teenagers, and your children may be unsafe for you as well. And you may be really stuck with, do I take my children and try to free them from this oppressive environment, knowing that it puts me at risk of either emotional or physical danger if I take them with me? Or do I leave them because there's so much damage that's already been done? And it's going to be a really destructive situation for myself if I take them, right? So there's a lot of women that struggle with that. My general recommendation is for younger children, you should absolutely take them, because it's very difficult to come back to the court later when you file for custody or he files for custody and say he's unsafe. Like, I should have primary custody because he's an unsafe parent if you left your children with him. You can't say that he's dangerous, but you were willing to leave the children with him for an extended period of time unsupervised. So you're setting yourself up for secondary custody and him getting primary if you leave the children with him. With regard to older children, if you feel like you need to leave them with their unsafe parent so that you can seek safety and get yourself established and then try to get into therapy or do things to restore your relationship with your children at a later time, that might be the best solution for you.
Wow, that was really helpful. I appreciate you expounding upon that and explaining that. And I think that covers that question. So let's move on to the next. This is a really good one. What is one thing you wish your clients knew before entering a custody case?
So 3 things: be prepared, be educated, and be well. And I'll expound on those just a little bit. So 1, you absolutely need to be prepared. And that's one thing you can be doing while you're in a relationship and maybe you're looking to leave. And how can you get prepared? You can be collecting evidence, whether that's capturing text messages or emails, saving anything that has words on it, things that he's saying to you. In the state of North Carolina, you can record your spouse as long as you are present in the conversation. So whether that's on the phone or in the room, and you can look at the consent laws for recording based on your state. So it's like 1-party consent or 2-party consent state. So if it's a 2-party consent state where you live, you have to have his permission too. So just be real careful when it comes to recordings. But in North Carolina, you can record him, and recordings are some of the best evidence. But while you're waiting, start collecting things that will show what type of abusive, oppressive environment you're in. Take photos. So if, he's ripped the door off the hinges or punched a hole in the wall or broken things, take photos of all that damage and make sure it's time stamped so you can prove the date and when those pictures were taken. Be educated. So get locked in with groups like Called to Peace Ministries or other nonprofit domestic violence organizations in your area, Facebook groups, other social media groups for women who are also going through domestic violence, who can help educate you on what resources are available, what are legal truths, what aren't. It'll help inform you about making the right decisions kind of moving forward, and then be well. I, as a legal advocate, have a really difficult time helping women advocate for themselves if they are just emotionally falling apart. So it's really important, again, get plugged into those support groups, get plugged into therapy, because the stronger you are, the better I am able to come walk along beside you, advocate for you in court, the better outcome you're going to have once we get there.
Wow, that is excellent. Yes. So get well. I love that. And we in our advocacy course very much emphasize that it's so important to be able to present yourself well in court, because when you fall apart in court, it does not look well to a judge. So kind of going from that question a little bit, I would like to go into this one, and that is, what are some factors to consider and be cautious about regarding what the court sees and expects?
So one of the things that I tell clients is that judges are watching everything, right? So they're watching what you look like, how you appear in court, what are you wearing, what kind of facial like all your nonverbal cues. So your facial expressions, are you rolling your eyes at your ex? Are you sighing? Are you slamming your hands down? Things like that. The tone of your voice, how emotional are you? Your word choices, everything you say and do in the courtroom, the judge is going to be observing. And the same thing can be true about your abuser. So the judge is also watching them. They're watching how they're looking at you. how they're responding to things that you're saying. So just even those tiny little things about how you're presenting yourself can make a huge impact in your case, because they're looking to see who's the most credible person, who's the person that has the most restraint, right? If you're coming into court and accusing your ex of being really abusive, really emotional, really angry, but you're the one sitting on the stand and you're being really loud, and you're the one yelling and being really defensive, then the judge is kind of sitting there like, you kind of coming across as being the one who's really angry and defensive. And then the batterer is going to gaslight, right? Turn it around on you and say you're the one who's actually the abuser, and you kind of look like one. So it's really important for us to be able to be calm and present ourselves really well when we're in the courtroom.
Thank you. I appreciate that. And let's go here since we're talking about presenting in the courtroom. Our next question is, how can one present a case when there are issues of coercive control and subtle mental, emotional, and spiritual abuse affecting the children? The children are afraid to talk openly to the counselor about their father and are even confused themselves, but are experiencing significant anxiety. I feel like I'm the only one who recognizes this. I am attempting to secure more than 50-50 custody for their stability, but have been told it's nearly impossible. What are your thoughts?
So custody sometimes can take a while, right? So sometimes we have to be patient. So with regard to the children being in therapy, I think that's wonderful. Therapists can be your best advocate in the courtroom setting, because many times they can testify and they can talk about things the children have disclosed when you can't get that evidence in any other way. It could be that the children either need more time to build rapport with this particular therapist before they begin disclosing, or it could be that they're in with the wrong therapist. It's really important to work with a trauma-informed therapist so that they're using the right skill set, the right modalities with your children in order to solicit the right information from them. So those are a couple tips I would give. Either give it more time so they can build rapport, or potentially think about switching therapists if you could. If you have an abusive spouse, they're probably not going to consent to switch. But if you have the ability to make sole legal decisions and you can do that, that's something you might think about. The other option, if they're old enough and they're willing, you potentially could bring them into court and they could speak to the judge either in chambers, or they could testify in open court about what they're experiencing. But if they're not openly talking to a therapist, I don't know how willing they would be to openly talk, in a courtroom setting. But just be patient, don't give up. Listen to your kids, help them feel supported. If they feel supported and they feel like they have a voice, they will eventually learn to speak up. That being said, don't interrogate them, right? Don't ask them questions to solicit information. Let them talk openly, and just help them to feel supported when they do that.
Thank you. That was really helpful. What is the best tool or resource to find a lawyer with experience and education in domestic violence and coercive control cases?
Yeah. So I get asked that question a lot. And my number one referral source actually is Facebook. So there are single parents and single mom groups that you can join on social media, and they talk. So they get together and they talk about what their experiences have been like in this particular court system with this particular judge. And then they talk about their attorneys, like what attorney have you used? Who's good? Who's not good? What types of particular cases? And the majority of my referrals come from a single moms group here in this area. So I would encourage you to look at Facebook in particular and see, is there like a single parents group, or is there a high conflict custody local group in your area? And you can ask for referrals.
Wow. Yes, I know, like, single groups that I'm in often talk about you. I'm in Wake County, so I'm in the same county as her. Often talk about Tiffany. And I even went in there to ask what questions they had. So it does get around very well. She is known as one of the best in the area for domestic violence in every group I'm in. So I always see her name pop up. I'm like, oh, I know her. She's great.
Thank you. And the other thing I'll say, Lauren, is don't let Google be your what's the word? What's the word I want to use? Don't let Google influence your decision to hire an attorney. Just because someone pops up as like number 1 or 2 on your Google search, or they come up in like Avo or Legal Match or is highly ranked or listed, that means they're, generally speaking, they're paying a lot of money in marketing to get highly ranked. It doesn't mean they're the best attorney in that area. And the other thing is, know what you can afford. Right. So if you contact an attorney and they're $500 an hour and it's a $10,000 retainer and that's way out of your price range, find someone that is within your range, because you don't want to hire someone and then have them withdraw from your case when you're only a few months in and then you're left without representation.
Yes, that's a really good. And somebody who does marketing a little bit here and there, I would definitely say those who come up highest in Google aren't always the best. And I can say in the single moms groups I'm in, Tiffany, like I think you're like ranked probably about number 3 on Google. There's a couple others that have really expensive marketing packages. So just make sure you get into some locals and get referrals. And because I've heard many horror stories from women that find not good lawyers, and it's a money pit. So.
Yeah. And I see a comment actually, Lauren, from Lily. And she says, I can't imagine not being naturally emotional in court when it is so heartbreaking, and in comparison with the abuser that shows no emotion, seems like the victim is at a huge disadvantage here. So Lily, I want to make a distinction between being genuine, like genuinely emotional, which I think is very important. Like, we don't want to go into court and be fake. But there's a difference between being genuinely emotional and then overly emotional or reactive. So it is very, very important to be able to tell your story. And that's something victims are not always the best at. Because it is so emotional, when we actually come to expressing what's happened, we kind of get tongue-tied. It's very important to sit down before court and actually start listing out like some adjectives. I have a list of adjectives that I keep in my office that I work with my clients on, to really sit back and go back and think about what actually happened like that night or during that incident. And let's describe it, because we like to think that people automatically know what happened in that moment, but they don't. They weren't there. So it's our job to be able to describe what we were experiencing, what our children were experiencing, with the same intensity with how we experienced it. Because all of those details are missing for the court. So absolutely, you should be emotional, because if you're describing what you've witnessed, your children being abused, and you're not being emotional, the court's going to look at you like, what's wrong with this person? But you have to be able to describe it. And if you're overly emotional, like you're sitting there and you're sobbing the entire time and you're not able to express or explain yourself, then that's where the problem is. So hopefully that distinction makes sense.
That was excellent. That was a really helpful distinction too. Because when you were saying that, I was like, wow, that'd be really hard. But yes, normal emotion is a good thing. So thank you for explaining that. I appreciate that. And this question I think is really good. What are your thoughts and experiences regarding self-representation and domestic violence in coercive control court cases?
It's a really bad idea. It's a really bad idea. I don't know how many victims I've seen who just had really bad outcomes when they've represented themselves. It's one thing if you need to go file for a restraining order or a domestic violence protective order, and you go down to the courthouse and you do that by yourself, because those are done ex parte, meaning the other side is not present. And generally, domestic violence protective orders or restraining orders are generally, they're going to err on the side of caution, and they're usually going to enter those on a temporary basis. Don't need representation as much when you're filing those. But when it comes to a return hearing for a permanent order, I highly recommend having counsel. They're going to know what questions to focus on, what evidence they need to present to the court. Sometimes folks get distracted with what they think is important, but it isn't. And then there are time restrictions in court. So they waste their time talking about things that really aren't relevant, don't get to the heart of the matter, and then they can lose their cases. The other thing I find is that judges get really irritated. They have less patience for people that represent themselves. I wish that wasn't the case, but unfortunately it is. And so if you can afford it, get a credit card, see if you can get a loan from a family member, see if you can find pro bono services, do something, but do get representation.
Thank you. That was really good. And then we have time for one more question. I found one more question I really like to ask since we have time for it. And that is, what can be reasonably expected about child custody? I know a specific, she says, for each individual case, but in general, for a few different examples could be helpful. Where physical abuse is present, evidence of abuse towards children or not, or where no physical abuse evidence. What about things like victims' reactions and reactive abuse?
That was a lot in that question.
Well, maybe we'll just answer a few parts of it. Kind of one I found. I was like, we had time. Let's ask this one. It looked really good.
Okay, so custody is dynamic. So what do I mean by that? Again, it depends on where you live, right? So it depends. If you live in farm country, North Carolina, it's going to be a whole lot different than you live in Wake County, Durham, or Charlotte. What the judges are going to do is going to vary greatly, and the facts it's going to vary too. So unfortunately, if you live in a more rural area, if there's domestic abuse, the courts may not take it as seriously, unfortunately, because some places that are a little more old-fashioned tend to discount domestic abuse and domestic violence. And if you're in a more metropolitan area, they tend to take that a little more seriously. But domestic violence is a factor in custody cases statutorily in North Carolina. And I know in other states, domestic violence is also a factor in custody cases as well. So it's definitely very important, if there is domestic violence, to talk about that in your custody actions. It's also very important to find an attorney who you feel like is an ally in your case and who believes you, and who is also verbally proficient in domestic abuse. So if you go and you have a consultation with an attorney and you feel like they don't get me, I don't feel like they hear me, they're not speaking my language, they don't seem to understand domestic violence, they're not going to be the best advocate for you, because when they go into court, they're not going to be able to tell that story, right, that we talked about before. They're not going to be able to convey the information to the court passionately and accurately, and it will have a detrimental impact on your case. So if you have an attorney that's like, it's not that bad, he only hit you one time, or he never physically abused you, so it's not abuse, or he's a great father, he never actually abused your children, just you. You've got to go to somebody else, because you're not with the right advocate. And having that spokesperson for you is a very important to having a good outcome. I know of a lot of attorneys in my county in particular who will tell people, oh, it's just, you're going to get 50-50 custody. You might as well just give him what he wants. I rarely have 50-50 outcomes in court. And it's just because I so fiercely advocate for my clients and I bring all the facts out. So just your attorney and you helping them, again, like I said before, be prepared, be educated, and be well. If the two of you come together as a team, there is absolutely hope that you can defeat the narcissist in court and get custody of your kids.
Wow, that's amazing. That was really helpful. And then I see a question over here. Is reactive abuse recognized in court because some abusers know how to push all the buttons that summarizes some marriages?
Yes. So some judges understand it. Some judges who practice in the area of domestic violence, they understand reactive abuse, and some judges unfortunately don't. And that's why I say be well, right? So if you get plugged into a good support group or you get plugged into a good therapist, they will really help you with the reactive parts of the abuse cycle and help you with controlling and managing your emotions and how you respond to the abuser. I just lost my train of thought there for a second. One of the important things for women that I tell them is your audience always, when you're separating and going through litigation, is your judge. It's not the abuser. It's not your spouse. So when you're interacting with him, whether it's through text message, email, you're on the phone, you're in person, because he could be recording you. When you're talking, talk as if you're talking to the court. You're not talking to him, because what you say could be captured and used as evidence against you later. And if you change your framework and you start thinking like that, that will really help you when you're communicating, and will help control, what comes out of your mouth, because it can be used against you later.
Thank you. That was really helpful. Well, all of this was so helpful today. I have learned a lot. And y'all, this is a 2-part series. So next Tuesday, we'll be asking more questions. So if you have any more, please let us know, and we'll be happy to look at those and see if we can address them for you. Tiffany, do you have anything else you wanted to add before we close out today?
Just that, for the ladies to have hope, and that, again, be educated, keep doing your research. There's so many great organizations out there. Don't get discouraged. I know it's so hard, right? They just distort our way of thinking. They use our children. They don't seem to care. And then quite frankly, they really don't. The only people they care about are themselves. But don't get discouraged. There is hope out there. There are people that can help you. You can turn your cases around. I've seen it done hundreds and hundreds and hundreds of times. So just, keep at it. It's going to be okay.
Thank you. That was really helpful. And I'm like already thinking of some other questions I want to ask next time, just like back in my mind as a survivor. I'm like, oh, I think this would be a good question to ask. And so I'm looking forward to next Tuesday at noon, y'all. So jump on in and join Tiffany again as she answers some more questions. I hope today is helpful for you, and you do have hope. As she said, I feel like, wow, this was some of these questions I was scared what the answers were, but it's like, wow, I feel hopeful now for a lot of people watching this, that they're able to know that things can be different. And it feels good to have control when you're a survivor and you felt so out of control. So I hope today you feel more in control of your situation, knowing that you can do something. So thank you for all that joined us. Thank you so much, Tiffany, for joining us today. We appreciate you so much at Call to Peace Ministries. So thank you so much again. And let us know if you have any more questions. We're happy to see if we can address them next week on Tuesday.
Yeah, thank you so much, Lauren. I really appreciate it.